As we've been reporting, ICAC released that bombshell report this morning concluding that Gladys Berejiklian was corrupt for not disclosing her relationship with Darryl Maguire and never reporting any suspicions about his conduct. Joining us live now is the Australian's legal affairs contributor, Chris Merritt. Chris, really appreciate you making the time. Thanks so much. Tell us, what's your analysis of that report today? It's several hundred pages long, so I'm not sure if you've got through all of it yet, but so far, what stood out to you?
I think it's a little over the top, 2 volumes, about 500 or 600 pages. And when you look at the substance of what's going on, to describe Gladys Berejiklian as seriously corrupt, I think it amounts to a debasement of the term. There's been no accusation that she received a pecuniary benefit. At substance, the most you could say, the clear-cut finding against her is that she failed to inform ICAC of her suspicion, or what ICAC says was her suspicion, that her former boyfriend was up to no good. She didn't benefit from that. The other aspect that I think is worth looking at is the source of this inquiry was ICAC's jurisdiction over the Ministerial Code of Conduct. Now, one of the findings against Ms. Berejiklian is that she exercised her duties in a partial or a not impartial manner when it came to benefiting Darryl Maguire's electorate. Now, if you have a look at the Ministerial Code of Conduct, there's a very clear carve-out for benefits that are designed to increase the popularity in an electorate of a particular politician. So I wouldn't be at all surprised if there is some consideration, at least, of an appeal aimed at challenging that finding, that Gladys engaged in partial conduct when it came to allowing grants to be sent to Darryl Maguire's electorate. That carve-out, I think, needs to be given very clear attention, because the politicians who drew up this code of conduct would have been aware that they would be possibly in the gun for doing exactly the sort of thing. And if it's now going to be considered corruption for politicians to allocate grants to electorates in the hope that that will increase their political popularity, I think we're entering a very strange new era of liberal democracy.
So, Chris, what options, what avenues are there for Gladys Berejiklian now? Because, as you point out, we've had these serious findings of corruption, but they're not being referred to the DPP for any charges. We heard from Margaret Cunneen a bit earlier in the program. She described that position as being a sort of halfway house. It's pretty tricky for Gladys Berejiklian to navigate.
Yes, I agree entirely. I think this is the worst possible outcome. Had she been referred, she would have been able to challenge the substance of the finding against her. As it is, she is limited to what's called judicial review. A superior court could still look at this and see if there has been what's called an error of law, not an error of factual analysis, but an error of law. And this is where this point about the carve-out in the Ministerial Code of Conduct could be a point that gains a little bit more attention over the coming days. I think that said, judicial review is a very inadequate form of oversight, or a method of holding ICAC to account. In effect, it limits the ability of anyone to look over ICAC's shoulder and say, well, this is not quite right, you didn't do this correctly. Or if it's infected with error, factual error about what happened, we will never know, because the New South Wales governments, a lot of them going all the way back to 1988, have decided that ICAC should not be subjected to a full appeal on the merits. That's the optimum outcome, and that's what happens in a court. If a court makes a decision, you do have the right to seek to appeal the entire decision. But that's not the case with ICAC. to a limited extent, it's the law assumes that ICAC is infallible, and that's not a good way to be.
I know that you've written in The Australian that the time delays in this process by ICAC was ludicrous, I think was the word you used to describe it. Is there any justification at all as to why this took so long? This has been hanging over the former Premier's head for 3 years now.
Look, I wouldn't think so. People who know a little bit more about ICAC's operations than me, and I'm talking about Jeffrey Watson, who's a former counsel assisting at ICAC. Way back in January, he was saying, look, this doesn't appear to be a complex matter. The argument, its substance, is fairly clear cut. And I agree with him entirely. I mean, the argument, when you get right down to it, are those points which I've just mentioned. And to drag it out for 20 months, I can't see any reason for that. And I think Premier Minns, Chris Minns, is being hopeful, I think, when he talks about introducing voluntary time standards. I mean, the Commission already has voluntary time standards, and they don't comply with them in, I think it's about 60% of matters, based on its own submission last year to a parliamentary inquiry. So I think the time for voluntary key performance indicators, I think that's long past. I think New South Wales needs to be sure that nobody else is subjected to such a ludicrous delay as has been the case with Gladys Berejiklian. It's just unfair.
Chris Merritt, really appreciate your analysis and for taking the time to join us today. Thanks so much.
Quite all right.